Good morning, everyone. My name is Richard Jolly. I'm a practicing attorney at Sussman Godfrey in Los Angeles, California, and I also serve as a research fellow for the Civil Justice Research Initiative here at UC Berkeley School of Law. It is my great pleasure to welcome you to this fifth in a series of Berkeley Boost webinars sponsored by the Civil Justice Research Initiative. The CJRI is an academic initiative that explores through interdisciplinary university-based research how the civil justice system can be made more available to everyone seeking relief. You can learn more about the work of the CJRI, including its diverse research, publications, and public programming by visiting our website at civiljusticeinitiative.org. The goal of this series of webinars is to explore the impact of important issues currently facing civil justice, particularly in light of the ongoing COVID-19 pandemic. With each episode, we aim to offer perspectives from both legal practitioners, scholars, and jurists, and we invite audience participation. So if you could please feel free to submit questions using the Q&A feature at the bottom of the Zoom, we will address them throughout our conversation. Today's episode will focus on how the pandemic has exposed and exacerbated racial and ethnic inequality in the United States. And to that end, we are very pleased to welcome as our guests, Zoë Melissa Polk and Richard Rothstein. Zoë is the executive director of the East Bay Community Law Center, which is the largest provider of free legal services in Alameda County. As executive director, Zoë leads the center's efforts to provide client-centered holistic legal advocacy, dismantle structural racism, and build a resilient and healthy community. Richard is New York Times bestselling author with his book, The Color of Law, A Forgotten History of How Our Government Segregated America. He is a distinguished fellow of the Economic Policy Institute and emeritus senior fellow of the Thurgood Marshall Institute at the NAACP Legal Defense Fund. Thank you so much for joining us today, Zoë and Richard.
Thank you.
It's a pleasure to be here.
To get us kicked off, Zoë, perhaps you can try to contextualize our discussion for the audience. Well, it's always imperative for us to recognize and address the inequalities in the United States. Why it is particularly important for us to have this conversation within the context of COVID-19?
Well, thank you again, Richard. I'm just again honored to be here. I have to say, The Color of Law is such an important work and is certainly a staff favorite at the East Bay Community Law Center. So I'm really grateful to be a part of this conversation and to really connect the dots in terms of our history and where we are today. So at a baseline, COVID-19 has been the most deadly for African American, Latino, and Native American communities. Essential workers, by another name, is women of color. In California, our Filipino nurses are on the front lines of our healthcare system, while Filipino Americans account for at least 35% of COVID-19-related deaths in California's Asian population. And hate violence and employment discrimination against Asian Americans in the diaspora have increased exponentially. So to your question, race is central to any conversation about the coronavirus. Again, that's the baseline. Perhaps what needs to be interrogated is why people in power, predominantly white people in power, including lawmakers, the drug makers, healthcare executives, remain invested in a myth of race neutrality.
Richard, is that your understanding as well? Are we seeing problems from are the systemic levels, are the systemic problems of inequality exacerbated as a result of these power imbalances and the historical issues that you outline in your book?
Sure. Once we have established a rigidly segregated society, as we have done, in which African Americans many of them are consigned to single neighborhoods which are lower income and more overcrowded than other neighborhoods. You don't need race-specific policies to make conditions worse, to make inequality worse. Race-neutral policies that build upon segregated patterns exacerbate their effects. So, as I alluded to a minute ago, the fact that we created a segregated country in the 20th century that resulted in African Americans living in more overcrowded conditions than whites on average makes it inevitable that when you get a pandemic like COVID, African Americans are going to suffer greatly simply because social distancing, for no other reason, is much more difficult in overcrowded conditions. The effect on children is enormously different, not because the COVID is a race-directed policy pandemic. It picks on everybody equally if it can find them in equal conditions. But we have children home from school now and in overcrowded conditions. There's a lack of access to internet. Even if families have an internet, they may have one computer that has to be shared by 3 different children being homeschooled. We have differences in educational opportunity for African Americans and whites that existed long before the pandemic. But what that means is that when children are homeschooled, rather than being schooled in their classrooms, it means that parents of different educational levels are able to impart different kinds of educational opportunity to their children at home that exacerbates the achievement gap between Black and white children. When we emerge from this crisis, the achievement gap will be exploded. It was serious to begin with. It will be much, much more serious after the crisis is over and children return to school.
Zoe, that matches up with what you're saying, that race neutral is actually race exacerbating. It exacerbates these effects through essential workers being synonymous with the works of Black and brown individuals. What else have we seen specifically from the pandemic that has exposed and exacerbated these inequalities? You mentioned the essential workers. What else have we seen specifically in relation to COVID-19?
Sure, yeah, so at East Bay Community Law Center, we engage in community lawyering across the full suite of housing issues. So we protect the constitutional rights of homeless communities, curbside communities. We zealously represent people who are in eviction proceedings, and I have to just do a plug that our team got the longest and strongest eviction moratorium in the country last week. So in Alameda County, no evictions can take place before 2021, and that is due in large part to the work that our housing team has done. And then the third arm of our EBCLC's housing work is that we write public policy to build wealth and housing stability for communities of color, including the African American community that was displaced right here, or someone's right here in Berkeley. And so, based on this position of who we're providing counsel to and who we're, as lawyers, as community lawyers, who we're in conversation with, there are 3 main things that are abundantly clear. One, all the things that Richard was talking about, explicitly racist housing policies and subsequent race-neutral fixes. The idea that we discriminated for decades, we were very racial specific about who could live where, who could own property, who could not own property, who was property. That was all very specific. And then there was a point in the mid-20th century, we said, okay, we're not going to do any race. We're going to become race neutral. And then the idea was everything was supposed to be okay. But layered on top of centuries of racial discrimination, we have the outgrowth of what we have now. So this has created a current reality that African Americans and Latinos are more likely than whites to rent and more likely to be evicted and to be housing insecure. We know that as lawyers, community lawyers who are working directly with the clients who are most impacted by the coronavirus. I would say a second theme that's coming up from us is historical segregation and divestment from Black neighborhoods, divestment from Native American reservations means that Native Americans, African Americans, and other communities of color are more likely to live in food deserts, places where there's not grocery stores nearby. They're more likely to have poor air quality and water quality, and less likely to have hospitals nearby. Decisions about where hospitals are placed are very much match up with the color of law. If you look at old maps of how cities were redlined and you see where hospitals are placed, it all matches up today. And then the third piece I think that we're seeing, I know that we're seeing, is that since African Americans were systemically prohibited from building wealth via home ownership, and home ownership is how most white Americans have built and inherited their wealth, African Americans are less likely to have emergency savings and are more likely to be in service-oriented jobs. And then this makes social distancing harder, and it also puts the entire Black family at risk. So those are just the 3 main elements that we're seeing. The confluence of this history and this lived reality is what makes COVID-19 so deadly for African Americans and for communities of color.
Richard, a lot of those points that Zoe was making, you outlined very thoroughly in your book. Can you speak a bit to the historical and structural problems that are plaguing us in the midst of this plague?
Sure, I'd be glad to. In the mid-20th century, during World War II, and especially immediately after World War II, the federal government began an explicit racial policy to suburbanize the entire white working class population into single-family homes, many of them ringing metropolitan areas, creating a white noose around every metropolitan area. Here in the Bay Area, for example, during World War II, San Lorenzo was created as an explicitly white community, although black and white workers had both flocked to this area, the Bay Area, to work in war industries. San Lorenzo was created for whites only. And that was true of all of the single-family home suburbs that the federal government created. For public housing for war workers, the federal government created 5 projects in San Francisco for war workers during the war. 4 were for whites only. 1 was for African Americans. That created an African American neighborhood in San Francisco, hadn't existed before, the Fillmore District. And then later, after World War II, the federal government moved whites out of those public projects into single-family homes. Well, as Zoe said, that's the way that the big wealth gap that we know today that seems to be a race-neutral phenomenon but affects all the inequality that we see today. That's how it was created, because these single-family homes that the federal government created on an explicitly racial basis for whites only, African Americans could have afforded to move to them. They were very inexpensive at the time, cost about $100,000 in today's money. I described one of them in an article that was posted today in the New York Times. It would be in the Sunday paper about an area in San Mateo where homes during World War II sold for $5,000 a piece, about $100,000 in today's money. They're now worth $1.5 million. So as Zoe pointed out, in 1968, we passed a law. We said, okay, African Americans, you can now move to this community. At $1.5 million, working class families of either race can't afford to move. And we have no policies today. We know what they are, but we have no policies today that are going to redress that unconstitutional violation of the creation of this suburban community and all the others in the Bay Area on a racially explicit basis. Let me say one thing, though, about wealth building. White families, as Zoe alluded to, gained wealth from the appreciation of the value of their homes. From an example I just gave in today's article, from $100,000 in the 1940s to $1.5 million today. The white families used it to send their children to college. They used it to perhaps take care of temporary emergencies, unemployment or medical issues. They used it to subsidize their retirements, and they used it to bequeath wealth to their children and grandchildren, who then had down payments for their own homes. African Americans were prohibited from accumulating this wealth. Today, African American incomes on average are about 60% of white incomes. African American wealth is about 5% of white wealth. Now, there's a whole story of unconstitutional federal policy to create the income gap. But if you assume the income gap of a 60% ratio, you think that African Americans would have 60% of the wealth as well. People could save the same amount of money from the similar incomes. But the reality is that African American households have wealth at 5% the rate of white households. And that enormous disparity that locks African Americans mostly into rented apartments, much lower rate of home ownership than whites, locks them into less well-resourced neighborhoods, as Zoe said, neighborhoods without even access to grocery stores that sell healthy food. That wealth gap underlies the racial inequality we have today, and it can't be resolved simply by race-neutral, non-discriminatory policies. We need explicit policies to redress it. And it can't be just home ownership. But let me say this, there's a lot of emphasis on how we have to increase African-American home ownership. I agree, home ownership can be a good thing. But the only way you get wealth from home ownership is if you manage to buy a home in a neighborhood that's about to appreciate faster than other neighborhoods. You have to be smart, you have to be a good speculator. Buy a home in a neighborhood in this San Francisco Bay Area that's about to gentrify, that hasn't gentrified yet. A far more powerful way to build wealth for African Americans is to enable them to have incomes that are high enough so that they can save. It's not that home ownership is the only way to generate wealth. And the reality is that African Americans own homes that typically have generated less wealth than white homes. So it's not a panacea. It's not a magic bullet. We need a minimum wage that's twice what people are talking about now, so that families can afford to rent decent homes and save and build wealth in that way. So we should not forget income policies as a major cause of the effects of ongoing segregation that we have. They're as important as home ownership and housing policies.
Richard, what are the points you make in your book?
I think
sorry, go ahead, sorry.
If I can, Richard, I think we'd be remiss in this moment to not talk about the role of state-sponsored violence towards communities of color throughout history. So certainly we're in a moment now where there's increased attention to a centuries-old issue of police killing Black people with impunity. But state-sponsored violence has been used as an arm to prevent integration, actively prevent wealth building among communities of color, particularly among Black folks as well. So when you had the Great Migration in the early part of the 20th century, where Black people were leaving the American South and going to places like the Bay Area of California, going to places in the North, and they were, going, and getting these jobs that were based on the war economy and hoping to move to the suburbs out of the cities, out of the public housing. And white residents said no. They were back to the, violence took place, bombings of houses, and other, cross burning, all sorts of violence took place to tell Black people they were not welcome in white neighborhoods. And these actions that were taken towards them were either just ignored by the police department, or the police department may in fact have been a part of it. So it's important to acknowledge that state-sponsored violence acting as an important enforcement arm to the devastation of and to the divestment of wealth from Black communities. And when we think about that now, we think about, again, the way that Black people have been policed throughout history. And as the state acts as funneling people into prisons, getting to this notion we in contemporary times we call mass incarceration, you funnel mostly Black and brown people into prisons, you're taking them out of the workforce, and you are taking an income earner, a potential income earner for a family out of the family unit. And that is also detracted from people's ability to build wealth. And then subsequent to getting out of prison, there's all sorts of host of laws that prevent you from gaining employment because of a criminal conviction. So this system, we refer to as structural racism, how racism exists across multiple institutions, the housing industry, the real estate, the realtors, politicians, functioning with police across multiple institutions to create a present state of structural racism now, where we have whites predominantly in power, and Black folks and people of color not having any of the same social or political capital or economic power that white folks have.
That violence predominates. And another way that we've seen it, Richard, you write about how the interstate highway system was used to destroy the types of communities that were built that might have developed into wealth centers. They were actively destroyed. In all of these areas, we're seeing this type of violence. Could you speak a bit about the physical destruction of Black communities?
Well, through the federal highway system, certainly. In many cities, the interstate highway system, when it was built in the 1950s, delegated to local officials the design of the routes of those highways, and local officials frequently used the interstate highway system when it was first created either to create boundaries between African American and white neighborhoods that would make them impassable and difficult to cross. In fact, the Federal Housing Administration's official manual, recommended those kinds of physical boundaries to separate Black and white neighborhoods. This was an explicitly racial policy. Perhaps the best known of these is the Dan Ryan Expressway in Chicago, that was a rigid barrier between Black and white neighborhoods. In my book, I describe how Interstate 95 in Miami was designed explicitly to demolish a thriving Black neighborhood outside downtown Miami and move the Black population to a more distant ghetto that would make it more difficult for them to interact with the white population. So you're absolutely right about that. I would like to, if I may, make a comment about Zoe's comment about violence, which is right on point. There were hundreds and hundreds and hundreds of cases in communities all over the country where police-sponsored and frequently police-organized violence drove African Americans out of apartments and homes that they had legitimately rented or purchased in previously white neighborhoods. This is actually how I got started on the research with The Color of Law. I read a Supreme Court decision, Parents Involved, in which Chief Justice John Roberts said that the segregation of Louisville, Kentucky was de facto. The government had nothing to do with it. And I remembered reading about a case in Louisville, Kentucky. The community, one of the two communities he described as having de facto segregation, where a white homeowner in a single-family home had an African-American friend living in the center city of Louisville, renting an apartment, a decorated Navy veteran. He bought a second home, the white homeowner bought a second home for his friend because that was the only other way he could buy it, and then resold it to the friend. And when the friend moved in, an angry white mob surrounded the home, protected by the police, threw rocks through the windows, dynamited and firebombed the home. But when the riot was all over, the state of Kentucky arrested, tried, convicted, and jailed with a 15-year sentence the white homeowner for sedition. This was, if anything, was a 14th Amendment violation. This was. Here in the Bay Area, the writer Jessica Mitford, in her autobiography, A Fine Old Conflict, describes how she and a group of left-wing, communist sympathizing white people went to an area of Richmond called Rollingwood to try to protect an African-American family who had bought the first home in that white community. And the police protected the mob. The mob, again, threw rocks and committed violence against the home itself, drove the family out, put Ku Klux Klan symbols around the neighborhood, around the home. This was all explicit state action, and it's never been remedied. Every one of these constitutional violations, whether it was the restriction of suburban homes, single-family homes to whites only by the Federal Housing Administration, whether it was the participation of the police in violence to drive African Americans out of their homes, every one of them was a constitutional violation. And it's my judgment, my view, that as Americans, we have an obligation to remedy civil rights violations. It's not just an opportunity, it's an obligation. So long as we thought that this was de facto segregation that happened by accident, it's easy to think it can only unhappen by accident. Once we understand that this was created in a blatant violation of our Constitution, it's civil rights violations, we have an obligation to take extreme action and policy to remedy these the segregation that we as a community have created.
As we think about taking action, especially right now in the middle of the pandemic, there's a great question from the audience that brings up something we talked about earlier, the eviction moratoriums. These can be incredibly helpful in the short term to address pending evictions as a result of the economic impact of COVID-19. One of our audience members notes, however, that this can also harm minority landlords who are in the process of trying to manage their properties in that sense. How do we recognize that something like a neutral policy of eviction moratoriums can actually have negative effects on other parts of the community?
I appreciate that question. I think that we at East Bay Community Law Center hear a lot about the mom and pop landlords and small landlords. It's always important to start from the facts is that is a very, very minuscule population of the landlords that we, that are that this moratorium will impact. Overwhelmingly, it's not the mom and pop landlords that are going to be addressed by this or impacted by this. I think, but to this question of how, like, what are the larger systemic issues that we need to do to create sustainable solutions? Particularly since this is a legal call, I think what we need to sit with is that race neutrality is legal fiction. Okay, so as lawyers and judges and legal scholars and civically engaged people, we must reckon with the damage that this legal fiction that things can be race neutral has wrought. If we look around in this moment right now at who holds the power, who holds the wealth, and who holds the health, then we get to the objective fact that our system of government is not race neutral. It is in fact very race specific. And our history and current reality demand targeted and specific strategies to ensure that race no longer predicts whether you will thrive or survive.
recognizing that race neutral is a fiction, Richard, you suggest in your New York Times piece today that one way we can try to address this issue is through local civil rights groups. Can you speak a bit to that?
Well, I'm very encouraged that we may finally be at a point where we begin to address some of these things. The Black Lives Matter movement was phenomenally inspiring. Over 20 million Americans participated in it, more whites than have ever before been involved in any kind of civil rights activity. But the participants in these demonstrations need to move beyond sign waving and slogans and social media and begin to focus around specific policies in their communities that can redress segregation. What my Times column today is about is how in many, many cases, the developers, the real estate agencies, the banks that cooperated with the government in creating segregation in every metropolitan area in this country are still around, or their successors are still around. And those institutions, those financial institutions, those real estate agencies, those developers have a moral obligation to redress the segregation that they contributed to creating, but they won't fulfill that obligation unless civil rights groups in their communities begin a campaign to put pressure on them to do so. So that's what I was writing about today. This is not going to happen by itself. As I said, the policies to redress this are well known. What's missing is not just a generalized awareness of racial inequality, but civil rights groups that are as intentional as the civil rights groups of the 1960s were in identifying specific policies and taking action to make it uncomfortable to perpetuate those policies. Let me make one other comment about Zoe's last comment. I think it's important to, and you're all lawyers, I'm not, so you'll forgive me for trespassing on your territory, but it's important to remember that race-neutral policies, the policies on their face are race-neutral, can have a disparate impact. And one of the biggest legal challenges that I think your profession is facing at this point in the area of civil rights is having a realistic understanding of how policies that have a disparate impact on African Americans and on other racial groups can be civil rights violations, can violate the Fair Housing Act, can violate the Constitution. In my judgment, a policy that perpetuates unconstitutionally created segregation, and I'm not a lawyer, but even if it's race neutral, is unconstitutional. I'll zero in on one of them. Single family zoning rules in all white communities, or mostly white communities around this country, maintain segregation that was originally created on a racially explicit basis. In my judgment, those single family zoning rules have a disparate impact on protected classes, on African Americans in particular, and they should be subject to challenge. Of course, under the current court interpretations, we're not ready for that yet, but that's the kind of thing that I think you lawyers should be working towards.
Yeah, and I to that point about whose responsibility is it to lead this moment, and I appreciate Richard acknowledging the important work that the movement for Black Lives is doing. We also have to reckon with our Constitution itself has never been a reality for most of the people in this country. The 14th Amendment, which says, no state shall deny any person within its jurisdiction equal protection under the law, is also legal fiction. So we think about how do we really live into what the doctrine says or what the law says. That requires a very, very deep interrogation and understanding that if you have, predominantly white lawmaking bodies, if you have predominantly white police forces and fire departments, that means that we are engaging in race discrimination. So it's not race neutral because it doesn't say anyone can have a firefighter job. But if we actually look and see most firefighters or in this country are 80% white, then we're engaging in race discrimination. And so what the challenge for us is to acknowledge at the baseline that we're engaging in race discrimination in violation of the Constitution, and how are we going to address that from a political power structure standpoint.
Unfortunately, that is all of the time we have, but this conversation is just fascinating, and it could go on and on to address the historical issues that are outlined in the book, and then how we're seeing those, and Zoe, how you and your organization are working to address them today. Thank you so much for joining us. In addition, I want to thank the Executive Director of the CGRI, Ann Bloom, for organizing this event. And finally, before we sign off, I want to let everyone know that this is a series of webinars and that we will be continuing these into the fall. So keep an eye out as we announce more episodes exploring critical issues in access to justice. Thank you again, Zoe and Richard.